Be ready for the dictation. Start. The learned counsel for the appellants submitted that this is a case where it was proved beyond doubt that the deceased was shot by persons who were wearing police uniform. On the night of the incident, the three accused, namely Shyam Bihari, Anil Kumar Sharma and Arshad Ali, all armed constables, were patrolling the area as per evidence brought on record. Soon after the incident, these constables were found present at the spot. Hence, their presence at the scene of crime was confirmed not only by eyewitnesses but also by circumstances including the fact that certain empty cartridges recovered from the spot were fired from their service rifles. Thus, not only their presence was proved but another version of the incident case crime number 48 of 1987, depicting police action, confirmed that death was a consequence of police action. Therefore, the burden was heavy on the accused to explain these incriminating circumstances, and in absence whereof, an adverse inference ought to have been drawn against the accused persons. It was also argued that even if PW 3 and PW 6 could not identify the accused persons, they corroborated the prosecution story with regard to the manner in which the incident occurred, and therefore, their testimony could be used to corroborate the testimony of PW 15, who not only narrated the incident but could recognize and identify the accused persons. Thus, according to the learned counsel for the appellant, the trial court's verdict was perverse and rejection of the application seeking leave to appeal has resulted in grave miscarriage of justice. It has therefore been prayed that the appeal be allowed and the matter be remitted to the High Court to accord fresh consideration on merits. Per contra, the learned counsel for the respondents submitted that, firstly, PW 3 and PW 5, who were travelling with the deceased, have not been able to identify the accused as those who were involved in the killing of the deceased, and secondly, the deceased died of a gunshot wound which could be ascribed to a .12 bore weapon, not a rifle which was with the accused. Moreover, some of the empty cartridges lifted from the spot did not match with the rifles of the three accused, thereby giving rise to a possibility that someone else was also present with a rifle and had used it. In these circumstances, if the trial court gave the benefit of doubt to the accused, the judgment and order of the trial court cannot be held perverse as to warrant reversal in an appeal. With regard to the testimony of PW 15, the learned counsel for the respondent submitted that PW 15 has been found not reliable for multiple reasons. Firstly, he did not make disclosure to anyone of having witnessed the incident even though the villagers had arrived and congregated at the spot in sufficient numbers to instill confidence in any person to make a disclosure against any person regardless of his position. Secondly, instead of giving his statement to the investigating agency, the witness got an affidavit prepared from a lawyer who prepared not one but three affidavits identically worded. One was of PW 15 and the other two were of those two persons who could not appear as witnesses during the trial. This would indicate that those affidavits were prepared on legal advice.